So today I'm talking about dying without a will. Now, if you die without a will, it is what is called intestate. Okay, so it is a case of intestacy when someone passes away without a will. And there are special laws about intestacy. So a lot of people mistakenly think that the government gets everything if you die without a will, but that's not the case. There is a complicated schedule about who gets what if someone passes away without a will. Now, you can also have parts of a will fall into intestacy as well. So if someone doesn't give away their complete estate, or if they give it to someone who is then already passed away and they haven't left a backup provision, then part of the estate can still be intestate even if there is a will. So that's why the careful drafting of a will is important as well, to make sure that intestacy doesn't apply to any parts. Now, the laws of intestacy actually changed in 2017, thankfully, because they really needed a big update. Before 2017, the laws of intestacy said that if you had a spouse and no kids, everything went to the spouse, which is fine. But then the old laws said if you had a spouse and children, the spouse would only get the first 150,000, and then the rest would be split evenly between the spouse and the children. So this needed a significant update, which happened in 2017. So a lot of other laws have developed along the lines of what spouses should get if someone passes away. And generally, the law says that a spouse should be housed securely and get a nest egg. All right, so those old laws from prior to 2017 said that a spouse would only get the first 150,000 and then split it with the kids. Now, 150,000 is not enough for a house and certainly doesn't leave a nest egg. So that is the reasoning for some of the updates, but let me go through what the laws actually say now. And we've got this little summary that we actually give to people. Put it over here. When someone passes away without a will, we've got this information sheet so that they can follow through with it. So still, if there is a spouse and no children, everything still goes to the spouse. So that still stands. Now, interestingly, and this is the case even before the law changed, if you have multiple spouses, the spouses have to work out how to split that between them. It's not necessarily an even split. And in fact, the new laws have made it a little bit more difficult. So a situation where you might have multiple spouses is that you've separated from your previous spouse but haven't divorced, and you have a new spouse, and this is within this period of 5 years. All right, so it's quite easy to have a new relationship that is 2 years old and you still have a wife even though you're separated, or husband, vice versa, whatever. Now, so that's interesting. So the old laws used to say, well, if it was this many years, this is how it's split between them. Now the new laws say that they have to work it out between themselves. So we actually haven't had any cases go through the Supreme Court yet where we have multiple spouses fighting over how much they're supposed to get. But watch that space, because I'm sure it will happen. So if the person passes away without a will, so I'm really talking, the scenario is the husband passes away, there is a wife and children of that relationship, the wife still gets it all under these new laws. So she does not have to split it between children that were children of their relationship. All right. Now, it's slightly different though when there are stepchildren. So husband and wife, husband dies. He has children from his first marriage, so wife's stepchildren. In that case, the wife gets the first 450,000. So the 450,000 should be enough to house her. And then she gets an extra third of whatever else is left over. So there's her nest egg. And the remaining 2/3 get divided equally between his children, so her stepchildren, right? So that is the main big change in 2017. Then everything else has pretty much stayed the same as it was before 2017. So we've got, if someone passes away with no will, so laws of intestacy say no spouse, no children. So this person has passed away. Everything then goes equally to their parents if they still have parents. So you're thinking about a young person who hasn't done a will. They don't have a spouse or children yet. The parents get everything equally. Now this is interesting to think about, because what if the young person's parents are separated and perhaps they didn't have a relationship with one or other of the parents? So again, that's another reason why I do encourage young people to have a will. So no spouse, no children, it goes to parents. If the parents have already passed away, it goes equally to the brothers and sisters. If any of the brother and sisters have passed away, it goes to the children of those brothers and sisters. If for some reason the person didn't have brothers and sisters, so they're an only child, their parents have passed away, they're an orphan, and they've got grandparents alive, the grandparents will get it equally. If they don't have grandparents, their uncles and aunts, so their parents' brothers and sisters will get things equally. If a uncle or aunt has passed away, their cousins will get the part that the uncle or aunt would have had. So you can see there are so many options in the scale before it then goes to the government. So a person who passes away without a will, for it to go to a government must have had no spouse, no children, parents have passed away, no brothers and sisters, they've all passed away or not had children of their own, their grandparents are dead, and their parents didn't have brothers or sisters. And then it would go to the government. So it's a really long shot, okay? So that myth can be set aside. The government will very, 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 very rarely get anything if someone passes away without a will. But today I really wanted to highlight those differences that have come in since 2017 around what a spouse is entitled to and how it's split up, because now it's not split with children if they are biological children of the couple. It's only split up between stepchildren. And even then, the spouse still gets this concept of a house and a nest egg, so that the spouse is looked after how the law sees that they should. Hopefully there aren't multiple spouses in that scenario too. But look, I hope that that's helpful.